All right, let's discuss how treating children as a separate social group has evolved. Generally, it is a new concept. So we're going to start back to the Middle Ages and work our way to the present time. During the Middle Ages, the father was the final authority in the home on everything related to family matters. So children who failed to obey, they were subject to extreme punishment, whipping, and in some cases, even death. Back then, children had to take on adult roles very quickly. Boys learned to work on the family farms or in the family trades. Girls learned to care for the home. And they were married in their teens. And in some instances, newborns were handed over to nurses, wet nurses, they called them, to care for them in their early ages until they were about 2 years old, and then they could be groomed to do what they had to do. At that point, they're learning how to walk and talk and so forth. But in some instances, the parents were just let that newborn stage be handled by nurses. They were subject to strict rules of the home. If they were out of line, corporal punishment was what they were subjected to. If a child was born with a disability, they were turned over to the state or churches or even abandoned. Children's rights started to develop in England not until the 17th, 18th centuries, which seems extremely old, a long time ago, but not from the Middle Ages to 17th and 18th century. That's a big jump. So that's where the rights start to change. They start to recognize children and their rights. There was changes in family structure. The apprenticeship movement was established. There was the English Poor Laws and the role of the Chancery courts. So let me just kind of back up a little bit here. The changes in family style happened, and child care happened. Marriage was no longer an economical arrangement, but rather more of an emotional commitment, love. And this affected how children were then brought into the world and treated within the family. Even the treatment of children in school changed, but unfortunately physical punishment in school and mistreatment still occurred at this time. But importantly, children were starting to become their own social group. They were emerging as in and of itself a social group. The apprenticeship movement, this was a concept that began in Great Britain, where children were placed in the care of a quote-unquote master who trained them in a skill like blacksmithing. And this was done either voluntarily by the parents or involuntary, which means it was compelled by the government. In either case, the master became the complete authority or control over that child during the apprenticeship. And then once the child became of age, and they would just move on into that trade. The Poor Laws was kind of its first form of foster care. Generally speaking, it was statutes that were passed that allowed the state, through court appointment, to place destitute or neglected, they were either destitute or they were neglected, children in homes. And but they would become like servants in the homes of the affluent. This was the initial Poor Laws in 1536, and then in 1601 the Elizabeth Poor Laws. And this is where there was a system of the church wardens who oversaw these children, and in some instances they put them with the apprentices, or with the masters in the apprenticeship, or unfortunately into poorhouses. But this was just another avenue for children to be cared for outside of their home if their home didn't exist, or their parents died, or they were neglected in some fashion. And the Chancery courts, these have always existed, but they were primarily involved in dealing with people's property. They were protecting property rights and resolving conflict disputes between, folks in their jurisdiction. And later, their authority was given or extended to protecting the property rights and inheritances of children who had become orphaned. And they did this by appointing a guardian. There was a guardian to oversee their rights until the child became of majority. And the authority for doing this, the government's authority for doing this, was under the proposition that children were protected under the king. They were under the protective control of the king. The PARENS, PATRIAE, as they say, or the parent of the nation. I think it is what it stands for, the parent of the nation. So the courts operated on that proposition that the children were under the king's protective control. So the court's job was to protect their property rights and their inheritances, and by doing that, they appointed a guardian to them. And that's in the event that they were orphaned. Childhood in America. Well, in early colonial America, the country adopted the similar practices of England, of what they knew when they were in England. They adopted the poor laws, the chancery courts, and the apprenticeships as a way of dealing with children. Children were subject to physical discipline in America, and even more so in America than in England. Children were required to view the public whipping and execution of individuals, whether they were children or adults, and this was done as a learning function. This is how you behave in society. That's what the viewing was intended to do. But not long after that, in Connecticut was the first one, the child protection laws, but there were several other states, but Connecticut was first. Laws were soon passed that would protect children from these types of abusive behaviors or tactics, which was great. However, they weren't strictly enforced, and who were they enforcing them? Right, it's the parents, the parents who are engaging in the abusive tactics. Unfortunately, they weren't strictly enforced, and if they were, punishment was pretty lenient. And that is, the parent abuser. So that's what gets us here. Now we're talking early colonial times. How do we get to justice, juvenile justice? Based on what we already discussed, can you imagine that when it came to the law during this time, the law didn't distinguish between adult and juvenile offenders? Because now we're going to kind of switch gears to how do we treat children who commit crimes, not just misbehaving or committing crimes. I mean, children were treated cruelly at home, they were treated cruelly at school, and they were also cruelly treated by the law. Both adults and children were eligible for the same types of punishment. It wasn't until the mid-19th century that groups were formed to advocate for a separate legal system for children. As I said, children who committed crimes, they were treated the same as adults. And the laws applied the same. There was no separate court for the children. Children were mixed right in with the adults. And if a child stole something, they could be punished exactly like an adult who did the same thing. Despite their age, there was no age recognition either. Some laws were passed to give children an opportunity to be supervised. There was an attempt at that. It was some type of probation versus being imprisoned. And it usually involved petty things, petty types of offenses. But unfortunately, despite that option, most were sent to asylums. And the most serious of offenders were still imprisoned or whipped or put to death. Picture 9-year-old. That's what we're talking about. Anywhere between 7 and of age 18. It wasn't until three things. We had urbanization of the country. We had the child saving movement that we're going to talk about in a second, and the growing interest in the concept of parens patriae, parents of the nation. Those three things resulted in major reform and the creation of the juvenile justice system for children. Basically, its own court system for children and handling children who commit crimes. Urban growth created a number of issues. There was increased birth rates, there was more youths in trouble and therefore going into courts and clogging up the court system, and there were more youths committing crimes. These children were put in poorhouses, workhouses, right alongside adults who were also, suffering from social issues like poverty, but also, they were insane, they were diseased, they were vagrants, and there was a whole bunch of unhealthy conditions that these kids were being put into. So urbanization kind of started the train towards a movement for a juvenile justice system. And we first saw the child saving movement. And what happened was some began with a group of New Yorkers who they were prominent New Yorkers, who formed the Society for the Prevention of Pauperism. They concerned themselves with the inadequate moral training of children of the dangerous classes. I don't know what they've deemed the dangerous classes, but clearly it was those folks who could not morally train their children. So that's what they were focused on. Other groups that were formed, they focused on laws that controlled youth activities like drinking, delinquency, vagrancies, and they called these folks child savers. Gave them a title, child savers. And what they did, because they were prominent individuals in the city, because we're talking about New York or in New York State, they influenced the state to give the courts the power to commit runaway children or criminal offenders to specialized institutions. So they were focused on kids who run away and those who are involved in committing crimes, criminal offenders. And one such place institution that was created was called the House of Refuge. And it was a private facility. And these became a popular resolution for runaway children and criminal offenders, despite the fact that parents were objecting to it. The courts were still doing that. And it was initially run very much like a prison, but then later took a more lenient approach. From there, into the 20th century, the child savers continued to lobby legislators who ultimately created what we know as reform schools. And they began to care for these vagrant and delinquent youths. So we're still dealing with runaways and those children who commit crimes. And these were more state-run. So state institutions were popping up, not only in New York, but in various states, where children learned to work, they learned a trade, they received an education. They were subject to segregation, meaning they were in different ethnic, gender, race sections. They were segregated. But they were also subject to harsh discipline if they didn't do what they're supposed to do. And they were also poor conditions and poorly cared for. An alternative to reform schools that was proposed and passed was, and it was proposed and passed by a man named Charles Loring Brace, which is in the book, created the Children's Aid Society. And his goal was to remove children from the city environment and provide them with shelter outside the city, basically putting them in western farms areas. And children were placed on a train. They deemed it the orphan trains. And it made prearranged stops along the way throughout the state where a family could meet a child and then keep a child. The child can stay. And it was a good program. Many children found new homes, but also other children were subject to exploitation and abuse. And when we had the Great Depression, that put an end to the orphan train. And I did put a link on Moodle for a thorough discussion on the orphan train for you to review. The next change we saw that came down the pike for the juvenile justice system was the Society for the Prevention of Cruelty to Children. That was created in 1874. And as early as 1900, there was hundreds more. And what this society did was focus on abused children. So now we are stepping away from how society deals with runaways and children who commit crimes or children that are offenders to children who are abused. And this group was influential in getting legislation to pass that protected children from their caregivers, i.e. their parents or their guardians who neglected them or abused them. And that primarily meant feeding them and giving them shelter. If they weren't doing those things, they could be deemed neglected or abused. And what happened was parents were subject to criminal charges, or they were subject to have their children removed from their care. So that kind of is our first look at laws protecting children from abuse. Reform groups were concerned about the lack of due process that was available to children who were taken and confined or committed. Due process in its general sense, we're going to talk about it a little bit more, but it is a constitutional right for people, for adults. Adults are always afforded due process. It was very questionable whether or not children received due process, which technically means a fair judicial process. That's the definition we're going to use right now at the beginning stages of our talks in this class. So when you hear the term due process, it's a constitutional right, and it's a constitutional right of a fair judicial process. So kids were taken, and then they were confined. There wasn't any sort of going to court, having an attorney, and having, you get to speak your case. So the argument was children should not be treated the same as adults for crimes. And what they meant by that was the goal is to treat and rehabilitate children, not punish them. They wanted a review of the youth's circumstances that should be available to them. All the confusing rules and procedures in adult court could be a little bit more relaxed. in a judicial proceeding when we're trying to deal with treating and rehabilitating and not punishing. So our first court that was created is the Illinois Juvenile Court Act of 1899, and this was the first time a distinction was made between children who were neglected and those who were delinquent. There was a creation of a court system and a probation system for handling children's matters. And it allowed for children to be placed in institutions or reform programs that were run by the state. And there were special proceedings for handling the two separate matters: children who were neglected by their caregivers or abused by their caregivers, and those who committed crimes or who were runaways, the delinquents. And these types of laws or acts were passed throughout the country. And by 1925, juvenile courts were in every state. And the court was based on a child's non-criminal actions and status, not strictly whether or not they violated some criminal law. They didn't provide, however, these few points here are very important, so I am going to totally read them off the slide and describe them. Because all of these things exist in an adult court, these were things that children did not get yet, not at this point. It did not provide these juvenile offenders with a full array of those constitutional protections. Let's start with due process. And then there's illegal search and seizure. They could totally have been searched. They could totally be interrogated even without a parent, let alone a lawyer. They weren't entitled to a lawyer. That's a constitutional right. So they didn't have all of the constitutional protections that are afforded an adult in a criminal case. The court's process was one of, like, to be a parent. How are we going to treat or rehabilitate this offender? So it was more of a paternalistic approach. As I said, attorneys were not required. Hearsay evidence. Hearsay evidence is when somebody says what somebody else said. Okay? That's not allowed in court, but it was okay in this kind of proceeding, in a juvenile court proceeding. It was more laxed, and it still is today, and there's reasons for that we'll get into a little later on. The verdicts were based on a concept called preponderance of the evidence. That's a burden of proof. In a criminal case, if you're in an adult criminal court, in a criminal case, the burden of proof that the government has to prove that somebody committed a crime is beyond a reasonable doubt. If you ever watched any crime show or crime movie, you've heard that term, beyond a reasonable doubt. Preponderance of the evidence is a very low standard. Think of it as a percentage of 51 to 49. That 51 is your preponderance of the evidence. If you get to 51, then you're successful. So the burden was very low. And the major functions were to rehabilitate the juvenile offenders, which it still is today, and treat them. But this was a basic makeup of the first juvenile court. By 1925, it was in every state. And in 1912, the federal government got involved. The U.S. Children's Bureau was formed as the first child welfare agency, and they investigated all of these state juvenile institutions that were propping up. And the juvenile court system, like I said, did not afford the same rights to children as adults were afforded in the criminal system. And if I haven't said it yet, I hope, well, it'll just be a repeat if I said it, because I don't recall if I did, but I'm going to say it again. The reasoning was that the juvenile court system was to rehabilitate, not punish. Yes, I've said it. I said it a few times, right? That must be a question. But despite that purpose, that was not always the case. And I just want to reiterate the rights, because now there's some more up here. There was no right to counsel. There was no right to a jury trial. There was no right to remain silent, where you could be subject to interrogation without counsel or even a parent. You could be subject to an unreasonable search and seizure. You weren't entitled to confront your accuser, meaning that if somebody accuses you of a crime, this person punched me in the head, you have a right to cross-examine that person. They have to be there at the trial. You have the right to confront your witnesses. And you have to be put on notice of what you're being charged with, or what crime you're being charged with. That wasn't happening. And these reform efforts didn't really begin until the 1960s. New York created a family court system. It's all family court, that's the way it is now. All family court proceedings are in family court, which means anything related to custody of children, support of children, juvenile delinquency matters, abuse and neglect cases. And there's also a created category called PINS, persons in need of supervision. We're going to cover that a little bit more in the next section on status offenders. But it's a different type of offender, not an offender who commits a crime, but they might be someone who needs supervision. Social services, they got involved. These are the agencies that became the role in the court system that prosecutes or oversees or petitions for neglect matters, and the JD matters, and it's probation who handles the PINS matters. And I gave you the rundown of New York because they're the one that initially passed the first legislation, and it is the system that we have here today with those amendments that I told you about in October 2017, when they kind of redid the age of offender, broke that down. They took the 16, 17, 18-year-olds out of the adult criminal system. And here's where I remind you again to review that link of the breakdown. It actually gives you the breakdown of the family court system, as well as the ages involving the juveniles and what their titles are and what the crimes constitute. So recall that juveniles do not have constitutional rights. Well, the Supreme Court fixed that in a number of decisions that were brought before its attention in the 1960s and 70s. And the courts had issued numerous ones, a series of due process rights for juveniles, including all of those ones that I told you. So now they have the right to confront witnesses. They have a right to notice of their charges. They have a right to have an attorney represent them. They have a right to not be subject to unreasonable search and seizure. And they have the right to remain silent. So they got the basic constitutional rights applied in all juvenile proceedings. And that kind of takes us up where we are at this point. There have been some additional Supreme Court cases that provided further protections. We'll cover those a little later. I want to kind of do a little overview of what we're looking at for the 20th century here. The designation delinquent became popular at the onset of the 20th century when the first separate juvenile courts were instituted. And our definition is minors who engage in illegal behavior. Oh, I'm sorry. That's my next step. Take that back. My next thought. So minors who engage in illegal behavior were now viewed as victims of improper care at home. Okay? So rather than being the aggressor or the problem, they are now the victim. That's the 20th century view. Minors who engage in illegal behavior were now being viewed as victims of improper care at home. And this is where I was going with my next point. The state, this is a view, but this is what has been taken on. The state should, and the 20th century view is the state should act in the best interests of the children, and children should be given the care necessary to control their wayward behavior as opposed to being punished. And that is the standard that courts do apply today. Every time a court is making a case relative to a child, whether it's abuse or neglect case, or doing some adjudication in conduct that's criminal in a juvenile delinquency case, the standard that surrounds that all, and you would hear a court say that if you've ever been to a family court, or if you want to go sit in a family court, a lot of it is public, so you can watch. Best interest of the child. What is in the best interest of this child? That's what the court makes and bases its decision on. Okay, one last point on the development of the juvenile justice system before we switch over to status offenses and status offenders. I want to discuss the current legal status of delinquencies. So generally, children under the age of 7 are incapable of committing crimes. I said that at the beginning. Between the ages of 7 and 14, they can be responsible for their actions, but they may not fully understand the consequences of those actions. And because of that, there's been some Supreme Court cases relative to their punishment. We'll talk more about that later. Our I jumped ahead a little bit last time, so here's our definition that we're going to use for juvenile delinquent. A juvenile delinquent refers to a minor who commits a crime. A minor is defined by statute, and that differs from state to state. Most states, that means up to your 18th birthday. And this may also be the case for neglect matters too. Children who are involved in abuse and neglect cases, the age is 18. Once they turn it's up to their 18th birthday. Once they turn 18, they're considered an adult. And for crimes, it's going to depend on the different age brackets set forth by the statute of the state as to how they will be treated, whether they be treated as a juvenile delinquent, a juvenile offender, or a adult. So, juvenile delinquents are kept separate from adults in criminal cases when they are handling, when they have committed a crime. They receive different treatment than adults do. They will be dealt with by some form of a juvenile court. The court system, I'm stepping back to the crime difference for age bracket. I told you in 2017, before October 2017, New York and North Carolina were the only two states that tried 16, 17, 18-year-olds just like adults. New York changed that in 2017 and made those folks juvenile offenders, and in some instances deemed youthful offenders. Again, this is where I'll remind you to take a look at the New York website that I have linked there. So the court system has reformed its juvenile system relating to minors who commit crimes, and juveniles are handled separately from adults. Generally, it's depending on if it's a criminal juvenile delinquency proceeding, it will be non-public. Some family court cases are open. Abuse and neglect cases are not open court. Custody cases are. Most of the matters resulting in criminal offenses are sealed or kept secret. The juvenile does not end up with a criminal record, and they are throughout the process, throughout the juvenile delinquent process of a crime from beginning to end, it's called adjudicated. The offender is adjudicated, not tried. Adult is tried for their crime. They're treated, they're not punished. Law enforcement will generally, we'll talk more about law enforcement, but law enforcement will generally have one person who just handles delinquent offenders that they have to, review and investigate and go to court on. There'll be a designated, trained law enforcement who handles just those in their jurisdiction. Today, juveniles are treated according to their need for treatment, not for their seriousness of the act that they committed or the crime that they committed. Now, I say that, and there's a number of exceptions. And we're going to talk about some cases as we go along. The state of Florida tried a 13-year-old as an adult for murder because he killed his 6-year-old companion friend, neighbor friend. They were imitating wrestling, WWE wrestling moves, and he was a big 13-year-old and she was a little 6-year-old, and he suffocated her and was swinging her around, and she hit something in the home and she died. He was tried, the state of Florida tried him as an adult, and he was sentenced to life in prison. We'll talk about that case. Another case we're going to talk about is the young lady who assisted her boyfriend in committing suicide via text messaging. We'll talk about that case. She went to prison as well. So there's a lot, and we're also going to talk about the Slenderman case involving 2 minors who stabbed their friend 19 times, and she ended up surviving that, and the 2 young ladies were tried in adult court, and they raised various defenses of insanity. So we're going to talk about all that stuff. The next topic, though, we are going to talk about status offenses, and this is where our persons in need of supervision come in. They're not necessarily committing crimes, but these young individuals need some sort of supervision.